Parliament's Legal Committee has interacted with various stakeholders from the creative sector to gather input on the Copyright and Neighbouring Rights Amendment Bill 2025. The first group hosted included the mover and seconder of the bill, both MPs and musicians, alongside the Director of Copyright from the Intellectual Property Centre. The mover, Maokota North MP Hilary Chiaga, told the committee that the amendments aim to empower the creative industry, but that they had disagreed with government on mechanisms through which artists can earn from their work.
Why did the government fail to agree with you on such key matters where you are very informative and you have got the experience? We need to find out from you whether they were just falling on a deaf ear. Otherwise,
with the government, because whenever we talked about issues or areas where artists are going to get money, it was a challenge. Yet for us, coming up with this amendment was to make sure that artists' revenues are raised.
The second Bugweri woman member of parliament, Rachel Magola, said the private copyright levy is a straightforward means for the government to collect revenue. However, MPs raised concerns on how such a levy would benefit content creators directly.
A Dr. Hilderman who produced Tabitebi Kute can know who is consuming his music. It is permanently on a CD that he cannot account for. So it is my property that somebody is enjoying. I love government to chew this by giving me a percentage, by giving...
Because the resistance to some of the recommendations, especially the private copy levy, come from, we are going to increase taxes. That's what everybody is looking at. We are not looking at the benefit of the existence of the private copy levy.
Does it operate like a circle that content creators will belong to that circle and will be going to pick the money? Or it is a fund that is going to enhance the development and support of the industry? Is there individual benefit that will accrue from this fund? Or you are looking at collective benefit?
MP Asumani Basalira also criticized the proposal to establish a separate copyright authority, saying it conflicts with the government's rationalization policy. Instead, MPs recommended strengthening the Uganda Registration Services Bureau, URSB, with enhanced mandates, rather than setting up a new agency.
But here, being under URSB, even if you went there today, it is just a desk of not even qualified people.
I don't know how you would want this matter to be pushed in light of the existing government policy that is evidently against, creating more public institutions as a way of managing resources.
To suffer, would it be fatal if we maintained URSB? With enhanced personnel?
When you have URSB, where there's not one person who knows the industry, they are put in a job which they do not understand at all. We have a problem there.
The Director of Copyright at the Intellectual Property Centre, Norman Mbabazi, proposed maintaining the Office of Registrar of Copyright, appointed by the Minister and supported by a qualified expert in copyright law.
In their offices, and they are not aware of what's going on the ground. Everything they see, they meet at their desk. So, I don't mind whether the Registrar of Copyright is situated within URSB, but can this person be appointed as the law requires and is qualified in that manner, separate from the Registrar General? 4
associations under the Uganda National Cultural Forum also presented their views. They called for the deletion of Clause 5, which makes contract registration mandatory, and Clause 6, which proposes a 20-year reversion of contracts.
Allowing for voluntary contract registration. If you want to register registration should be voluntary. I think even in the current Copyright Act, registration of contracts is voluntary. 2, to safeguard the full property rights of rights holders and prevent loopholes that could be exploited by third parties through piracy.
I'm Nafka Farida at Parliament.